Hello friends, welcome to my channel. Today we are going to deal with functionaries under the code. Functionaries are person or a body of person or an authority set up by the law to discharge lawful institutional, governmental or political functions. They are essential for the proper functioning of the code. There are 5 functionaries exercising power and discharging duties under this code. The police. The police officer is an important authority who is the backbone of criminal law in India. They are responsible for maintaining the law and order of the country. The Police Act of 1861 is a comprehensive code that deals with appointment, dismissal, and functions of police officers. The main aim of this act is to recognize the police forces wherever necessary and to make police forces more effective. It contains 47 sections which deals with various aspects of police forces. Section 4 of the Act provides that the administration of police in every district rests upon the district superintendent of police under general guidance and direction of district magistrate, who is usually the collector of the district. Functions of the police. Section 23 of the Police Act 1861 deals with the functions of the police officer. It is the duty of every police officer to collect and communicate intelligence, to prevent the commission of offences and public nuisance, to figure out and bring offender, to promptly obey and execute all orders executed to him by any competent authority, to arrest all persons if any crime is committed and who is legally authorized to arrest. Importance of police under this code. Section 151 provides that it is the power to arrest a person without any warrant and the order from the magistrate to prevent the commission of any cognizable offence. Section 154. The police officer has the power to record every information provided orally if it relates to the commission of a cognizable offence. Section 156. It provides to the officer in charge of the police station to investigate any cognizable offence within the jurisdiction without an order from any magistrate. Second, public prosecutor. Any crime is a wrong against the whole society, not only against the individual. Thus, a public prosecutions are counsels on behalf of the society in such cases. Public prosecutor is any person appointed under Section 24 and includes any person acting under the direction of public prosecutor. Appointment of public prosecutor. Section 24 provides the public prosecutor for a high court requires at least 7 years of practice. Section 24 subclause 8 stipulates that a special public prosecutor requires at least 10 years of experience. Role of prosecutor. The main objective of criminal trial is to find out the truth about the guilt or innocence of the accused in order to secure justice in the society. Section 301 states that the public prosecutor has the authority to appear and plead before any court in any case entrusted to him. Section 321 establishes that a public prosecution can withdraw from prosecution against any person with the consent of the court. Defense counsel. Section 303 of the code confers right to be represented by a legal practitioner of their own choice to any accused person. Thus, the advocate who represents the accused and defends him from the conviction to which the accused is charged is known as a defense counsel. Article 22 of the Constitution provides the right to free legal aid to the accused. Prisoners, authorities and correctional services. The prison authorities are not directly governed by the Code of Criminal Procedure. The Prisoners Act 1900 is an important act which governs the various duties of prison authority. Section 3 of the Prisoners Act. The officer in charge has the duty to detain the person who is convicted until the person is removed in the due course of law. Section 4 of the Prisons Act gives the officer to return the order, writ or warrant to the court after the discharge of the person who committed the crime. Fifth, courts. The mechanism of whole judicial system of courts in India is divided into 2 types on the basis of nature of their area, district and metropolitan area. In districts, the setup of criminal court in district can be classified as 3-tier. At the lower level of judiciary, the courts are called the courts of judicial magistrate, judicial magistrate of first class, judicial magistrate of second class, special magistrates court. In the middle level of judiciary, the session is the unit and each district may be considered as one session. Court of session, additional court of session, assistant courts of session, and special courts. The higher level of judiciary includes two important courts, that is High Court and Supreme Court. Metropolitan areas, the courts which are at the session level are called metropolitan courts. They are two types, metropolitan session courts and metropolitan magistrate courts.